Welcome back to Octopus Legal Solutions. How are you all? Warm greetings to you all. The topic assigned for interaction is very interesting one. 70 years old fraud on Dalit Christians. Let us unravel the hidden secret for the last 70 years. Jai Bhim. Good news for Dalit Christians. Dalits never lose their Schedule Caste status and identity even after conversion. There is absolutely no legal necessity to get the controversial and offending Para 3 of the Schedule Caste Presidential Order 1950 declared as unconstitutional by any constitutional courts, as Para 3 is a dead letter and it has no life, no existence at all. Scores of people belonging to Schedule Caste communities secured employment under Schedule Caste reservations irrespective of their cadre, have been persistently groaning under the grip of fear to embrace Christian religion and to visit churches with an apprehension that they will lose the employment secured the moment they embrace Christian religion on account of the alleged religious restrictions clamped in Para 3 of the Schedule Caste Presidential Order 1950. For the last 70 years, Dalit Christians have been demanding the governments to extend the benefit of the Schedule Caste status to them also, under the misnomer that Para 3 of the Schedule Caste Presidential Order 1950 has been in existence and in force. The governments and the courts are also under the misnomer that Para 3 of the Schedule Caste Presidential Order 1950 has been subsisting in the eye of law. The great Constitution of India, drafted under the chairmanship of the global leader Dr. B.R. Ambedkar, came into effect on 26/1/1950. Dr. B.R. Ambedkar has taken every precaution to prevent exploitation, discrimination of any sort in drafting our constitution. Then how can anyone say the said constitution allowed discrimination based on the religion, permitting patently discriminatory Para number 3 of the Schedule Caste Presidential Order 1950 to subsist? Article 341 of the Constitution of India delegated the power to President of India to publish a notification specifying castes, races or tribes or parts of groups with such castes, races or tribes which shall for all the purposes of the Constitution be deemed to be Schedule Caste in relation to state or union territory. The Schedule Caste Presidential Order 1950 was published by the Ministry of Law under notification number SRO 385 on 10th August 1950 in the Extraordinary Gazette of India. From this it is clear that within a record time and at an unimaginable pace of 6 months 15 days of the commencement of the Constitution, the Schedule Caste Presidential Order 1950 along with the list of Schedule Caste allegedly collected from all the states in consultation with respective governors was notified. In the Schedule Caste Presidential Order 1950, shockingly, an alien Para number 3 sneaked into it stating that no person who professes a religion different from Hindu religion shall be deemed to be a member of Schedule Caste. The said delegated power under 341 mandated that the President of India, after consultation with the governor of the state or union territory by public notification, specify castes, races or tribes only, and it never authorized the President of India to whisper anything or add anything relating to any religion. Therefore, the President, while passing the said executive order, transgressed the parameters specified in Article 341 of Constitution of India. When the Schedule Caste Presidential Order 1950 was promulgated, identifying 1111 Schedule Caste as Schedule Caste in a record time of 6 months 15 days of the date of adopting of the Constitution, how was it possible? During the colonial regime, the then Census Commissioner of India, Dr. J.H. Hutton, conducted survey and submitted a list of scheduled castes to the colonial government of India, which in turn promulgated Government of India Schedule Caste Order 1936. In para number 3 of the said order 1936, Indian Christians were deleted from the list of scheduled castes, but not the Dalit Christians under various circumstances prevailed during the colonial regime. When the President of India promulgated Schedule Caste Presidential Order 1950, instead of resorting to the exercise as mandated in Article 341 of Constitution of India, simply copied down Government of India Schedule Caste Order 1936 and imported a lean theory of denying Schedule Caste status to Dalit Christians. For doing so, the President of India had no power and jurisdiction at all. Our great father of the Constitution, Dr. B.R. Ambedkar, drafted the Constitution in such a dynamic manner without giving any room for discriminating any person or group or race or caste based on the religion, as our Constitution is religion neutral. Article 14 of the Constitution of India contemplates equality before law. Article 15 contemplates prohibition of discrimination on the ground of religion, race, caste, sex, or place of birth, according to which the state not to discriminate against any citizen on the grounds of religion, race, caste, sex, place of birth, or any of them, and that no citizen shall on the grounds of religion, race, caste, sex, place of birth, or any of them be subject to any disability or liability or restriction. Article 16 contemplates equality of opportunity in the matters of public employment, according to which no citizen shall on grounds of religion, race, caste, sex, descent, place of birth, residence, or any of them be ineligible for or discriminated against in respect of any employment or office under the state. Article 12 of the Constitution of India contemplates protection of life and personal liberty. Article 25 of the Constitution of India contemplates freedom of conscience and freedom of profession, practice, propagation of religion, according to which all persons are equally entitled to freedom of conscience and the right freely to profess, practice, and propagate religion. These articles of Constitution of India are part and parcel of the Part 3 of the Constitution of India, the fundamental rights enshrined. Honorable Supreme Court of India in Keshavananda Bharati case held in no certain terms that even Parliament of India is not empowered to tamper with the basic structure of the Constitution of India. Then how could the President of India execute, promulgate Schedule Caste Presidential Order 1950 importing unwarranted para number 3, deliberately demonstrating discrimination based on the religion, denying Schedule Caste status to Dalit Christians, which was absolutely beyond the powers and duties of the President of India. Previously, the Honorable Supreme Court of India in Principal Guntur Medical College versus Y. Mohan Rao's case and in G.M. Armugam versus Rajagopal's case maintained that Dalit Christians will maintain the status of the scheduled caste after their reconversion into Hindu religion, provided their caste people recognize them, implying that religious conversion does not take away the caste and it continues to pass generations unabatedly. Various high courts, including Honorable High Court of Andhra Pradesh, Madras, held that Dalit Christians are also subjected to caste discrimination and untouchability. The Chairman of National Commission for Religious and Linguistic Minorities, Justice Ranganath Misra, in 2007 submitted report to the Government of India clearly stating that in our country there is absolutely no nexus between caste and religion, and that despite change of the religion, caste discrimination continues to haunt. The National Commission to review the working of the Constitution submitted a report to the Government of India in the year 2002, wherein it has categorically mentioned that scheduled caste people, even after their conversion into Christian religion, are continue to face discrimination and untouchability. It recommended to extend the benefits under SCs and STs Prevention of Atrocities Act to Dalit Christians also. The Honorable Supreme Court of India in Susai versus Union of India had the occasion of examining the constitutional validity of Schedule Caste Presidential Order 1950 with reference to Article 14, 15, 25 of the Constitution of India. In this case, for various reasons, the core subject matter has been hijacked and driven to unwarranted direction. In the said case, Honorable Supreme Court of India held that the petitioner failed to place required research-oriented reports stating that Dalit Christians are continue to experience the social stigma of untouchability. It was further held that merely saying that with the change of religion, caste would not be changed is not enough. Finally, the Honorable Supreme Court of India in the said case held that it is not possible to say that the President acted arbitrarily in exercise of his judgment in enacting Para 3 of the Constitution of India, Schedule Caste Presidential Order 1950. In this context, instead of criticizing the verdict of the constitutional courts on the offending para number 3 of the Schedule Caste Presidential Order 1950, let us unravel the hidden secret for the last 70 years playing deliberate fraud on Dalit Christians under the guise of existence of absolutely a dead letter, the para number 3 of the Schedule Caste Presidential Order 1950. From the interactions so far made, it is crystal clearly established that the offending para number 3 of the Presidential Order 1950 was imported maliciously and unhesitatingly in utter violation of Article 14, 15, 16, 21 and 25 of the Constitution of India. Under these circumstances, in the light of various verdicts of the constitutional courts, without disturbing para number 3 of the Schedule Caste Presidential Order 1950, while indirectly stating that change of religion does not take away the caste, without examining the offending para number 3 of the Schedule Caste Presidential Order 1950 on the touchstone of Article 13, Clause 2, Clause 3 of the Constitution of India, is there any legal necessity to approach constitutional courts with a prayer to set aside para number 3 of the Schedule Caste Presidential Order 1950, particularly when the real subject matter was always hijacked and taken to an unwarranted direction without addressing actual point in issue. The chief architect of great Constitution of India, Dr. B.R. Ambedkar, has already provided remedy in the Constitution itself in the form of Article 13, Clause 2, Clause 3 of the Constitution of India. Let us examine what they contemplate. Article 13, Clause 2, Clause 3 of the Constitution of India. The state shall not make any law which takes away or abridges the rights conferred by this part, and any law made in contravention of this clause shall, to the extent of contravention, be void. In this article, unless context otherwise requires, law includes any ordinance, order, bylaw, rule, regulation, notification, custom or usages having in the territory of India the force of law. Now, it is crystal clear that any order or notification published by violating the fundamental rights enshrined in the Constitution of India to the extent of contravention be void. Is para number 3 of the Schedule Caste Presidential Order 1950 promulgated in denying fundamental rights enshrined in the Constitution to Dalit Christians, Article 13, Clause 2, Clause 3 of Constitution of India render the said para number 3 void. Void means useless and unenforceable anywhere. The Honorable Supreme Court of India in Mahi Gowda versus Anke Gowda case held that there is no legal necessity to anyone to approach court of law seeking declaration that void transaction or exercise as void once again from the court of law. When the legal position is very clear, for the last 70 years, a deliberate fraud on Dalit Christians has been perpetuated by mischieviously branding legally dead para number 3 of the Schedule Caste Presidential Order 1950 as in force, deliberately denying Schedule Caste status to the Dalit Christians on account of the said dead letter. Schedule Caste people, though having interest and inquisitiveness to change their religion, are refraining themselves from doing so with an apprehension that they will lose their Schedule Caste status and benefits. There is a misnomer in circulation widely that Schedule Caste people, after taking baptism, will lose the status of Schedule Caste and will become BCC, which is nothing but a blatant fraud and deliberate violation of mandate of the Constitution of India. I have addressed communications to Honorable President of India, Prime Minister of India, Home Minister, Minister of Parliamentary Affairs and Principal Secretary of Law Commission, unraveling the hidden secret for the last 70 years and how the fraud has been perpetuated against Dalit Christians, depriving Schedule Caste status and benefits under the misnomer that para 3 of the Schedule Caste Presidential Order 1950 was in force, and requested therein to communicate all the departments of Union Government of India and to state governments not to treat Dalit Christians as BCCs and to treat them as Schedule Caste, and also inform therein that there is no legal necessity to wait for any order from any court for doing so. I received communication from Law Commission that my communication has been forwarded to Union Ministry of Law and Justice and it has been under examination. I also transmitted similar communications to all Chief Secretaries of 25 states and 6 Union Territories. I am receiving replies from them that my communication is under examination. I share this good news with you all that there is absolutely no legal barriers or constitutional barriers to Schedule Caste people to embrace Christian religion, and by embracing Christian religion they will not lose their Schedule Caste status and benefits. Stay tuned till our next video in our channel Octopus Legal Solutions, furnishing more details and answers to the practical problems being confronted by Dalit Christians regarding this issue. Jai Bhim.